We'll start the recording now. Okay. Good morning, everyone. I welcome you all to the 6th TGA Virtual Moot Court Competition conducted by Thomas George and Associates. My name is Rucha, and today I'll be your court master. I request all the participants to keep the cameras on throughout the proceedings and ensure any technical issues to be communicated via the chat box. For today, I warmly welcome today's judge, Advocate Tanvi Jain ma'am. Ma'am has worked with Panda Law for over 7 years and is currently a part of IP prosecution and disputes team. She advises and represents clients on matters pertaining to civil law, company law, commercial law, and intellectual property law, and regularly appears before all forums across Delhi. Tanvi ma'am has also a vast experience in handling trademark hearings before trademark registrars across India. At the firm, ma'am closely works with and represent companies such as Amazon, Lenskart, JK Lakshmi Cement Limited, Khaitan Edusers Private Limited, Rupa Publications, Bombay Shirt Company, Nizam's Kathi Kebab, Colonial's Kebabs, Ernst and Young's LLP, Jumbo Tail Technologies Private Limited, amongst other. I thank Tanvi ma'am for being here and for adjudicating this round. Now I would like Now I would like to proceed with the rules of the competition. Each speaker shall speak for 15 minutes to an extension granted by the judges. Uh, Structure of the proceeding would be as follows. Counsel 1 and 2 of the petitioner side, followed by Counsel 1 and 2 of the respondent side. I humbly request ma'am not to grant extension due to the fixed schedule. Steady internet connection should be maintained by everyone. Any judgment reports can be screen shared. In case during the round, if there is any internet interruption from the side of any of the participants, a maximum of 5 minutes extension will be provided, subject to the discretion of the judge. Now if it pleases the Lordship, we can commence the session.
Sure.
Now I request the speaker of petitioner side to.
I shall begin in 3, 2, 1. Greetings to the Honorable Ladyship. May it please the Honorable Court, today I, Ritu Karwa, appearing on behalf of the appellants ABC Bank in the present matter of ABC Bank versus XYZ Private Limited. The Council seeks permission to address your Ladyship as Honorable Bench collectively. Sure. Much obliged. The Council has approached this Honorable Apex Court under Section 62 of the Insolvency and Bankruptcy Code, challenging the decision of NCLAT and submits that by virtue of the same, the Court has full authority to pass any order, judgment, or decree of justice, equity, and good conscience. For the sake of brevity, the Council would be summing up the facts of the case in a few lines. Much obliged. ABC, a public sector bank, scheduled bank, disbursed a loan of rupees 500 crore to XYZ Private Limited. Upon the default by the respondent, that is the XYZ Private Limited, the account was classified as NPA, that is non-performing asset, on 1st April 2014. On multiple restructuring and OTS proposals were made by the respondents, that is the XYZ Private Limited. On 1st of Feb 2020, ABC Bank agreed for an OTS proposal, but that was also failed by XYZ Private Limited. Further, the COVID pandemic ventured and Section 10A was inserted into the legislature. Then my client, ABC Bank, filed Section 7 petition before the NCLT, listing the date of default as 1st May 2020. The NCLT dismissed the same as it was barred by Section 10A. Later, NCLAT further upheld the dismissal. Later, the client ABC Bank filed a fresh application under Section 7 on 1st Jan 2024. This time taking the date of default as the original NPA date, that is the 1st of April 2014. NCLT rejected the same and the same was affirmed by NCLAT. The council would be dealing with 4 issues in the present matter. The council, council would be dealing with first and fourth issue, and my co-counsel would be dealing with the second and third issue. Much obliged. The council will be dividing the submissions for issue 1 into 2 fundamental sub-issues. The issue 1 talks about whether or not a second application under section 7 of the IBC is barred by law. The 2 fundamental sub-issues under this are if the second application is maintainable as the earlier dismissal was not based on merits, and secondly, a fresh cause of action has been arisen through multiple acknowledgements.
Yeah.
It is humbly submitted before this honorable court that the second application filed under section 7 of the IBC is not barred by res judicata, as the earlier application was dismissed solely on a technical ground arising from the operation of section 10 and not on the merits of the claim. Your Honor, the council should proceed to demonstrate that the foundational elements required for the res judicata are conspicuously absent in the present matter, and further, that a fresh cause of action has arisen and has independently arisen through multiple statutory acknowledgements. The council seeks permission to proceed with the submissions.
Sure.
The council would be dealing with how the second application is maintainable as the earlier dismissal was not based on merits. Your ladyship, section 11 of the CPC enunciates that no court shall try any suit or issue which was directly and substantially in issue in a former suit, provided
I'll stop you there. Is CPC applicable to NCLT?
Yes, your honorable ladyship.
Proceed.
In a form, provided that such issue has been heard and finally decided between the same parties by a court of competent jurisdiction. The statutory requirement for that should be that the matter should be heard and finally decided presupposes the court must have afforded the parties an opportunity to advance their submissions and after consideration of the same should have rendered a decision on the merits. In the present matter, the first application filed by the financial creditor under section 7 was dismissed by the NCLT and the NCLAT exclusively on the basis of the bar under section 10A, a bar that is purely statutory in nature. The authorities did not undertake any exam.
Sorry, I'll just hold you there. Do you have
Yes,
any precedents with respect to IBC? Where a section 7 was initially dismissed and then another fresh section 7 was filed and which was allowed?
So, Your Honor, the precedents relate to when the application has been dismissed on a technical ground, a fresh application can be filed. Since the previous application has not been dealt on the merits, that's why, and it was dismissed on the basis of a technical ground, then a fresh application can be filed and it does not attract the doctrine of res judicata.
And which case is this?
In the case of Prem Kishore and others versus Brahma Prakash and others, it was clearly observed that when a formal proceeding is dismissed on account of a technical or procedural ground.
Was this with respect to IBC again, or was this a general civil suit?
It pertained to a general civil suit, but in the present matter, the doctrine of res judicata has been applied in the present matter, and regardless of the fact that the doctrine of res judicata gets applied in a lot of different circumstances. So the mere technical error cannot dismiss the application in its entirety.
Okay. You're saying it's res judicata and there's no concept of a continuing cause here?
So there is the council would be dealing with the same in the next sub issue, that is a fresh cause of action arises through multiple acknowledgements.
Okay.
Oh, yes. Much obliged. The council would like to draw your ladyship's attention to the object and ambit of section 10, which unequivocally talks about the suspension of the initiation of the SCIRP where the default has occurred during the 10A period. The legislative intent for the same, as discussed in the case of Sushma Paranzape versus Rohan Developers Private Limited, does not contemplate any adjudication on the merits of debt, liability, or default per se. Accordingly, a dismissal grounded in Section 10A cannot be construed as a final decision on the merits for the purpose of res judicata. In the present case, dismissal was blatantly non-meritorious, and hence the NCLT did not venture into any adjudicatory analysis of the substance of the claim. As such, the bar of res judicata cannot be invoked, for it applies only where there has been a final determination of the merits.
Okay.
The council seeks permission to proceed with a sub-issue 2.
You can proceed with sub-issue 2.
Much obliged. To further substantiate the argument, the council would like to prove how a fresh cause of action has arisen through multiple acknowledgements in the present case. It is humbly submitted before the Honorable Court that by virtue of 238A of the IBC, the provisions of the Limitation Act 1963 stand attracted to the applications under Section 7 and 9. Article 137 of the Limitation Act governs the proceedings of the IBC in this context and prescribes a limitation period of 3 years commencing from the date on which the right to apply accrues, that is the date of default. However, Section 18 of the Limitation Act also says that a written acknowledgement of the liability signed by the debtor prior to the expiry of the limitation gives rise to a fresh period of limitation from the date of such acknowledgement. This position has also been authoritatively affirmed by the Supreme Court in Dena Bank versus C. Shivkumar Reddy, wherein it was held that each acknowledgement of debt serves to extend the limitation period by an additional of 3 years. Consequently, each acknowledgement constitutes a fresh cause of action which is unaffected by the principles of res judicata as mentioned in Bombay Gas Company Limited versus Jagannath Pandurang. In the present case, although the account was declared NPA on 1st of April 2014, a series of OTS proposals spanning from 2017 to 2022 constituted unequivocal acknowledgements under Section 18 of the Limitation Act. These acknowledgements repeatedly extended the limitation period. Accordingly, the second application filed under Section 7 on the 1st January 2024 is well within the extended limitation and cannot attract the bar of res judicata.
Okay.
If your ladyship does not have any further questions, the council would like to move forward with issue 4.
You can start with issue 4.
Much obliged. Issue 4 essentially talks about whether a case can be admitted if the default has occurred and the application is within the limitation despite an error in the default of date. It is humbly submitted that where the occurrence of default is undisputed and the application is well within the limitation, the petition must be admitted despite an error in the date of default. This is because the core essentials, debt and default stand fully satisfied, leaving no discretion with the adjudicating authority to reject the application. Such errors are merely curable irregularities and can be rectified without the dismissal. Before the submission start, the council would like to point out that there has been no error in the date of default as far as the application. But if maybe there would be a default that could be dealt likewise. Your ladyship, the existence of debt and default mandates the admission. In the present case, the appellant has filed a Section 7 application seeking the initiation of CIRP. Under the IBC, two essential elements for the same should be satisfied. That is, the existence of a financial debt and secondly, a default in the repayment. Section 5.8 of the code explicitly defines that a financial debt is constituted when money disbursed against the consideration for a time value of money. Your ladyship, this honorable court in M. Suresh Kumar Reddy versus Canara Bank has clearly held that non-payment of even a part of a debt when it becomes due amounts to default. More importantly, the court clarified that once the default is established, an order under Section 7 must follow, leaving virtually no discretion with the NCLT to refuse the admission. Applying the same to the present case, a term loan of Rs 500 was disbursed by the financial creditor. The corporate debtor defaulted on 1st of April 2014. Thereafter, repeated OTS proposals continued till 2022, clearly acknowledging the outstanding liability. Your ladyship, an error in the application does not nullify the admission.
So, just one question here. Now, if there's a
Yes.
specific form and manner in which the provision has been given and it forms the date of default, how is it not mandatory then?
I couldn't hear you.
Sorry. So what I'm saying is there's a particular form which has to be filled out while you're applying for a Section 7. So everything that's been given in the specific form becomes mandatory to be filled in. So on what do you have precedence to show, or do you have any interpretation of the law to show that such date is not mandatory in that case?
Your ladyship, the question which would be dealt with my co-counsel in issue 2 regarding to your question as to if there has to be the mandatoriness of the
Hmm.
Section 7. My co-counsel would be briefly dealing with the same.
Okay.
Okay, much obliged. In the when a date of default is insignificant, an incorrect or mistaken mention does not render the application defective, so as long as the facts on record substantiate the true date and no prejudice has been caused. The NCLT has been consistently held that the insolvency proceedings are to be driven by substance and not by technicalities, and that the procedural irregularities cannot overshadow clear evidence of debt and default. Your ladyship, this principle has been reiterated by the NCLT in Canara Bank versus Wasabi Power Services Private Limited, where the tribunal held that the correction of an incorrect date of default is permissible
Sorry, which
before
tribunal
final
was this?
adjudication.
Which
I'm so,
tribunal was this?
the NCLT.
The NCLAT. Okay.
The NCLT.
NCLT. Okay.
Yes. Much obliged. The tribunal held that the correction of an incorrect default date is permissible before final adjudication, provided it does not introduce a new cause of action and causes no prejudice to the corporate debtor. In the present matter, there is no new cause of action. There is only identification of the correct commencement point of a continuous ongoing default. Therefore, the rectification of a bona fide error cannot be a ground to dismiss a Section 7 petition, particularly when the essentials of the debt and default are fully satisfied. If your ladyship does not have any further questions, my co-counsel would be dealing with issue 2 and 3.
Yeah, we can proceed with issue 2 and 3.
Am I audible?
Yes, you're audible. You can start.
Yeah.
Just before
proceed.
I start, I wanted to seek permission of the court master to present the screen in between the oral submissions.
Just a minute.
You can grant the permission to the research TGA 28 researcher.
Yes, just a minute. I'm just trying to find where can I grant the permission.
If it's okay, then I can start the oral submissions, and if the permission has been granted, then you can maybe type it out in the chat box.
Uh, Okay, you can share it.
Okay, thank you. So I'll start in 3, 2, 1. Greetings to the Honorable Bench. As stated by my co-counsel earlier, my submission would pertain to the two issues. Firstly, issue 2, stating whether or not mentioning the date of default is mandatory in the applications under IBC. It is humbly submitted before the Apex Court that the requirement to mention the date of default is neither mandatory nor sacrosanct in an application under IBC, so long as the same can be determined from the evidence placed on record. Before I make my submissions, it is respectfully brought to your ladyship's attention that the relevance of this issue must be examined from the standpoint of whether the date of default is indeed sacrosanct, especially when in the present case the date of default has in fact been mentioned. The Council will endeavour to demonstrate that the date of default is not of paramount importance in the application itself, and therefore, in the present matter, the dispute surrounding the appellant's alteration of the date of default ought not to carry any significant consequences. Your Ladyship, my submissions under the issue would pertain to the two sub-issues. Firstly, that the date of default is not necessary if it can be determined from the record or evidence of default. And secondly, that the non-mentioning of the date of default doesn't render the application defective. Going ahead with my first submission under this issue, the date of default is not necessary when it can be ascertained from the record or evidence of default. Your Ladyship, the impugned procedural requirement arises from Part 4 of Form 1 under IBC for an application under Section 7. Your Ladyship, Section 7 provides a substantive criteria for admission, namely the existence of default and completeness of the application. Your Ladyship, it is my humble submission that the date of default is a mere procedural detail and omitting the same does not attract any fatal consequences.
So
This
I'll stop
honorable
you right
court,
there. How is limitation calculated in IBC?
so a limitation period is calculated from the date of default.
How is it not important then?
Your Ladyship, the Council clarifies that the date of default is indeed an essential element in an application. But the mentioning of the same in an application, the non-mentioning of the same in the application does not attract any fatal consequences so long as they can be determined from the record or the evidence of default.
Okay, the same question that I'd posed to your co-counsel. Is there any precedence to that effect? Where it says that the
Uh,
date is not sacrosanct and it is not mandatory to be mentioned in the form?
Certainly, Your Ladyship. In the case of Geocon Infra Private Limited versus Bridge Gopal Construction Company Private Limited, the NCLT in this case clearly admitted the
Which
application.
NCLT was this?
This was NCLT New Delhi.
Okay.
So, in this case, the adjudicating authority clearly admitted the application when the date of default was not mentioned. Uh, for the sake of brevity, I quote the NCLT. Uh, in the present matter, the date of default has not been specifically mentioned neither in the demand notice nor in Part 4 of the application. Hence, we observe that the non-mentioning of the date of default does not affect the merits of the present case.
And which year
It
was
is
this?
this was in the year 2023.
2023. Okay.
If your ladyship does not have any further questions,
We'll
may I
proceed
move
with
on
the
to my
next.
submission?
Yeah.
Much obliged, your ladyship. Although Part 4 of Form 1 includes a space to mention the date of default, an omission is not a fatal since the timelines under Section 7, Clause 5 are directory or not mandatory, as was held in this case of Surendra Trading Company versus Jugilal Kadapa Jute Mill. Your ladyship, going ahead with my second submission under this issue, that the non-mentioning of the date of default does not render the application defective. Your ladyship, it is humbly submitted that what must guide the interpretation of Section 7 is the purpose and not the procedure. It is the objective. Its objective is timely initiation of CIRP upon the proof of default and not the rejection of the claims on a technical procedural basis. Your ladyship, the purpose of specifying the date of default is merely to identify when the default occurred for the purpose of examining the CIRP, whether the CIRP should commence or not. If the same can be established from the record, the objective is met. Your ladyship, in the present case, the date of default is very well established from the date of NPA classification and the other OTS exchanges and other evidence. Your ladyship, accordingly, in the present case, that the date of default is not sacrosanct under Section 7 of the ADC. If your ladyship does not have any questions, may I move on to my third issue?
You can proceed with the third issue.
Much obliged, your ladyship. Moving on to the third issue, which states that whether or not the date of default changes based on the facts and circumstances, or is it to be taken as the date of NPA in all the banking matters. Your ladyship, my submission under this issue would pertain to two sub-issues justifying the two applications made by the appellant respectively. Firstly, the first application was made with bona fide intention pursuant to the restructuring agreement that had taken place between the two parties. And secondly, the second application, which was filed with taking the NPA date as the date of default, is in tandem with the NPA classification date, which is operative date of default under the IBC framework and RBI Prudential. Moving ahead with my first submission. Your ladyship, the Section 18 of the Limitation Act states that the fresh period of limitation begins when a written and the signed acknowledgement of the liability is made before the original limitation period expires. Your ladyship, the correspondence in the present case, right from 2014 to 2022, as reflected in the para 4 of the moot proposition, clearly demonstrates that the corporate debtor was in a continuous state of default. Every restructuring proposal and OTS request was merely an effort to cure the same underlying default. Acting on this continuing default, the financial creditor, the appellant in this case, with a bona fide intention, relied on the corporate debtor's subsequent acknowledgement of debt under OTS of May 2020, which constituted a fresh cause of action under Section 18 of the Limitation Act. Based on this, the financial creditor considered 1st May 2020 as the operative date of default while filing the first application under Section 7. Your ladyship, this approach has been further substantiated and supported by the NCLAT in the case of Pradeep Madhukar More versus Central Bank of India, which held, and I quote, "The restructuring agreement is the authoritative source of establishing default, since each such acknowledgement revives the limitation period as the OTS and restructuring attempts demonstrates a continuing cause of action, and thus modifies the date from which default must be computed for the purpose of an IBC application." Therefore, your ladyship, the financial creditor's first application was filed bona fide, premised on the valid and a judicially recognized acknowledgement of liability. Now, your ladyship, coming to the dismissal of the first application under Section 10, the Honorable NCLAT in the case of Puneet Bhatia versus ASREC Limited held that there must exist a clear and a direct link between the alleged date of default and the impact of COVID-19. In the present matter, your ladyship, no such link exists. In fact, the restructuring of March 2020 itself establishes that the default originated due to the pandemic. It merely addressed one of the tranches under OTS where the original date of, in fact, the original date of default 2014 persisted. Therefore, your ladyship, first application was dismissed on a flawed application of Section 10A because the default was not caused by the pandemic. There was no direct evidentiary link, and Section 10A was never intended to cover pre-existing defaults such as ours. Your ladyship, the financial creditor originally relied on the 2020 OTS acknowledgement in good faith to compute the limitation. However, that acknowledgement does not shift the original date of default. The original date of default remains 2014, which is long before the pandemic period, and there is no legal or a factual basis to link the debtor's inability to pay with the COVID-19 period. Therefore, your ladyship, Section 10A has no application. If there are any questions of your ladyship, the council would like to address those.
Do you have any parliamentary debates, any discussions that had happened before 10A was passed? To understand what was exactly the purpose or the object of 10A?
Your ladyship, may I take 1 minute?
Sure.
Your ladyship, as stated by my co-counsel in the first issue,
Hmm.
the uh, intent of Section 10A was brought because of the inability of the corporate debtors during the pandemic, not being able to pay their debts, and therefore Section 10A was a temporary relief provided to those companies and those entities who could not who had been who were unable to pay the debt which they had undertaken. So it was just a temporary relief. But in the case of Sushma Paranjpe case, a pre-existing default cannot be negated. Only the default that has occurred between the period of 25th March 2020 to 24th March 2021 can be considered as a can be considered as a period where the certain amount of relief under Section 10A can be provided.
Okay. Was it only with respect to initiation or was it with respect to any default that's occurred?
It was the default that had occurred. Default in between the period as mentioned before.
Okay.
Much obliged, your leadership. Your ladyship, the council seeks permission to move ahead with my second submission under
Sure.
this issue. Much obliged, your ladyship. Your ladyship, the NPA date, the second submission is that the NPA date reflects the initial default date, but which may vary with later acknowledgements in the banking matters. Your ladyship, the second part of issue 3, which talks about NPA being the date of default, it is our respectful submission that the date of the NPA must be treated as the operative date of default, as it is the first and unequivocal point at which the debt had become due and remain unpaid. Your ladyship, it is humbly stated that IBC is a time-bound remedial statute, and certainty limitation is essential to its functioning. The NPA classification is not a mere internal banking formality, where it is actually the statutory recognition of default grounded in the RBI's prudential norms. Your ladyship, once a borrower's account has been classified as NPA, the default is formally crystallized and the creditor becomes entitled to trigger legal remedies. The applicant therefore submits that treating the NPA date as the date of default maintains the uniformity, predictability, and financial discipline envisaged under IBC framework. Your leadership, the RBI's guidelines on restructuring do not suggest that the pre-existing defaults are automatically nullified by subsequent restructuring agreements. This further stance has been upheld in the case of Puneet P. Bhatia as cited by the council earlier. Your leadership, rather, the restructuring serves to provide a temporary relief while acknowledging the debtor's existing financial obligations. Taking this particular stance into consideration, the appellants filed the second application, wherein the date of default was rightly considered as 1st April 2014. It is humbly submitted that using the NPA date as the date of default, it is consistent with the RBI regulatory framework. Your ladyship, in the general banking matters, and as opined by the Supreme Court in the case of Babulal Vardharji Gurjar versus Veer Gurjar Aluminium Industries, the date on which the loan account is classified as NPA should be considered as the date of default for the initiation of CIRP under IBC. Your Ladyship, in this case, the appellant's second application therefore aligns with the IBC's aim of ensuring timely insolvency resolution to maximize asset value and protect creditor interests.
So for my E,
That
can you
is
just give me the timeline as to when your first application was and what steps have you taken till the next application?
much obliged, Your Ladyship. So the first application, uh, Your Ladyship, the first application was filed on 1st January. Your Ladyship, the first
Like a
application
brief
was filed.
list of dates and events I would want.
Much obliged. So the first application was filed on 1st February 2022, taking the date of default as 1st May 2020, and the second application was filed on 1st January 2024, taking the date of 1st April 2014. And in between, the before the application was filed, the corporate debtor issued various letters right from 1st July 2014, and this communication extended to 1st January 2022. So we see that right from 2014 to 2022, the corporate debtor was in a continuous state of default.
But hasn't your asset been declared NPA back in 2014?
Yes, your ladyship.
So what is the purpose of having your OTSs then?
Your ladyship, the OTS was initiated by the corporate debt for seeking a settlement so that there can be a one-time discharge of the debt. So that is the reason why various letters were exchanged, and even in this case, the appellate had given a sanction also in 2020 of giving them an opportunity to pay the debt. But however, they failed to pay the entire debt. That is the reason why the appellant had to file the application under Section 7.
Okay.
If there are no further doubts, then may I conclude my submissions?
Sure. Just conclude it in a minute because I think the time's up.
Yes, Your Ladyship, much obliged. Before I move on to my prayer, I would like to clarify. I would like to rectify my co-counsel's uh, statement in the first issue, where the Your Ladyship had asked whether CPC is applicable to NCLT. The answer actually is that CPC does not apply to the NCLT because NCLT is guided by the principles of natural justice. So that is the rectification here. Um, However, that is not strictly so. Uh, the council would like to move on to the prayer. Much obliged, Your Ladyship. The appellant most humbly, respectfully prays before this Honorable Apex Court that it may be pleased to find in their favor and to uphold the civil appeal preferred by the appellant in the present case and quash the orders of NCLT and NCLAT. And secondly, hold that application under second application under Section 7 is not barred, and or pass any other order which may be granted in the ends of justice, good conscience. Much obliged, Your Honor. It was an honor arguing before the Honorable Ladyship.
Court Master, can I just get 5 minutes before we start with the respondents?
Yes,
I
ma'am.
just want to fill in my score sheet till then.
Yes, ma'am.
Thank you. Yeah, we can proceed.
Now I will request speaker one of respondent side to start with the proceedings.
Is the council clearly audible and visible to the bench?
Yes, you are.
Much obliged. May it please the Honorable Court, the council seeks permission to refer the bench collectively as your ladyship.
Sure.
Your ladyship, I will be speaker 1, dealing with issues 1 and 2, taking 15 minutes of this Honorable Court's time, whereas my co-counsel will be speaker 2, dealing with issues 3 and 4, taking 13 minutes. We would like to reserve 2 minutes for rebuttals.
Sure.
Much obliged, your ladyship. May it please the Honorable Bench, the Council seeks permission to proceed with the statement of facts. As your ladyship, certain facts were distorted when they were presented by the side appealants.
Okay.
Much obliged, your ladyship. Your ladyship, in the instant case of ABC Bank versus XYZ Private Limited, ABC Bank is the financial creditor and the appellant party who sanctioned credit facilities of rupees 500 crores to XYZ Private Limited, who is the corporate debtor. Your ladyship's the corporate debtor, which is the side respondents, initially repaid regularly, but defaulted, leading to the loan being classified as an NPA. After which, your ladyship, the debtor repeatedly sought OTS, one-time settlement, from July 2014, with an OTS finally being accepted in February 2020. Your ladyship, the financial creditor then cancelled the OTS due to non-payment during the COVID period and rejected subsequent OTS offers that were made by us, the corporate debtor. Your ladyship's thereafter, the financial creditor filed a Section 7 IBC application before the Honorable NCLT, mentioning the date of default as 1 May 2020. Your ladyship's, the Honorable NCLT dismissed the case as it was barred by Section 10A IBC. An appeal was preferred by the financial creditor to the Honorable NCLAT, and the same was also dismissed on merits. Your ladyship's, then the financial creditor filed another application under Section 7 by changing the date of default to 1 April 2014, which was the date of NPA. The Honorable NCLT dismissed the application on the grounds of res judicata. An appeal was filed before the Honorable NCLAT, which was dismissed on the same grounds. Thereafter, your ladyship, the current civil appeal has been filed by the financial creditor before the Honorable Supreme Court, hence the present matter.
Okay.
If your ladyship is satisfied with the statement of facts, the council would like to proceed with the statement of jurisdiction. Much obliged, your ladyship. Your ladyship's, in the instant case, we as respondents concede that the Honorable Court has jurisdiction under Section 62 of the Insolvency and Bankruptcy Code. If your ladyship is satisfied with the statement of jurisdiction, the council seeks permission to proceed with their arguments.
Sure.
Much obliged, your ladyship. Your ladyship, it is humbly submitted before the Honorable Court under issue 1 that in the instant case, a second application under Section 7 of the IBC is indeed barred by law. Your ladyship, the argument set forth by the side respondent in issue 1 is twofold. Number one, that the doctrine of res judicata is applicable to IBC proceedings. And second, that protection of Section 10A cannot be taken away. Your ladyship, it is humbly submitted under sub issue 1 that the doctrine of res judicata is applicable to IBC proceedings. Your ladyship, to substantiate my argument, I'd like to take your ladyship through the case of Vikas Dahiya versus Aero Engineering Limited, paragraph 30 and 31 in the respondent's compendium.
Which court
If
is
the bench-
this?
Sorry, your ladyship.
Which court is this?
Your ladyship, this is the NCLT Delhi. Your
This is
ladyship.
NCLT.
Indeed, your ladyship. If your ladyship may permit, I'd like to present my compendium before
Sure.
the Honorable Court.
Sure.
Much obliged, your ladyship. Your ladyship, is the compendium clearly visible to the bench?
It is.
Much obliged, your ladyship. Your ladyship's, in the instant matter, it has been cited a paragraph from the Honorable Apex Court's judgment in Abex Singapore Pte Limited versus Committee of Creditors of Educom. It was held that the doctrine of res judicata is indeed applicable to the proceedings of IBC, your ladyship. Your ladyship, in that particular case, the Honorable Supreme Court had held this principle of res judicata is embodied in relation to suits of Section 11 of the Code of Civil Procedure. But even when Section 11 does not apply, the principle of res judicata has been applied by courts for the purpose of achieving finality in litigation.
Okay.
Your ladyship's, in the instant matter, the NCLT had held in view of the principle laid down in the above judgment, strictly doctrine of res judicata is applicable even to the proceedings under IBC, and challenge to the same is incidental or collateral proceedings amounts to abuse of court process. Your Ladyship's, now I'll prove before the Honorable Court how this particular principle is applicable in our case. Your Ladyship's, pardon me for saying this, but if I may be bold enough to state before the Honorable Court that the appellants have presented before the court a distorted version of facts, which are conclusively false. Your Ladyship's, I'd like to point the Honorable Bench's attention to the memorial submitted by the appellants, that is the opponent side appellants, paragraph 2, page 1 of their arguments advance. If your Ladyship may allow, I'd like to present the highlighted part, your Ladyship.
Sure.
Your Ladyship, the appellants in their submission have said categorically in paragraph 2, for res judicata to apply and for a case to be decided on merits, the court has to give an opportunity to the parties to put forth their case, and after considering the same, it will give its decision. Your Ladyship, they have clearly stated, in the present matter, the first application filed by financial creditor under Section 7 was dismissed by the NCLT and NCLAT on the basis of bar under Section 10A, which is statutory embargo, and was not adjudicated on the basis of merits, your Ladyship. Your Ladyship, however, I'd like to take your Ladyship through paragraph 9 of the moot proposition. If your Ladyship, if the proposition is visible to
Yes, it is.
the Honorable Bench. Your Ladyship, from paragraph 8, we can conclusively say that we are talking about the first application. Financial creditor filed a Section 7 IBC application before the Honorable NCLAT, NCLT, before the corporate debt hearing 1 February 2022 by mentioning the date of default as 1/5/2020. The Honorable NCLT dismissed the case as it was barred by Section 10A IBC, and appeal was preferred before the NCLAT, and the same was dismissed on merits, your Ladyship. Your Ladyship, thereafter the financial creditor filed another application under Section 7 IBC on 1 January 2024 before the NCLAT, your Ladyship.
Before the NCLT then?
The
fresh 7, yeah.
The first application was before the NCLT, which was also dismissed, your Ladyship, and thereafter they approached the NCLAT. Your Ladyship's, contrary to what the appellants have submitted, the first application was dismissed on merits by the NCLT and NCLAT. And to validate that particular claim, I had showed your Ladyship the moot proposition itself, your Ladyship. Therefore, your Ladyship, it is humbly submitted before the Honorable Court that the first round of litigation has thus attained finality. The appellant cannot now re-agitate the same debt through a second application with an altered default date on the same cause of action. Your Ladyship, it is humbly submitted under sub-issue 2 that the protection of Section 10A cannot be taken away. Your Ladyship, the legislative purpose of Section 10A, if I'm not wrong, your Ladyship has also questioned the side appellants on this particular aspect. Your Ladyship, herein lies the answer. The legislative purpose of Section 10A was to provide a breathing space to corporate debtors during unprecedented economic disruption caused by the pandemic. Your Ladyship, if the financial creditor in the instant case is allowed to file a fresh application with a different date, then Section 10A becomes entirely meaningless and redundant. Your Ladyship, the Honorable NCLT Mumbai in Inakshi Sokti recognized this particular mischief. Your Ladyships, to prove the veracity of my claims, I'd like to take your Ladyships through the case of Inakshi Sokti versus Starlight Systems, paragraph 10 and 11 of the respondent's compendium. If your Ladyships permit, I'd like to present my compendium.
Please present the screen.
Your Ladyship, is the screen clearly visible?
Yeah.
Much obliged, your Ladyship. Your Ladyships, in the instant case of Starlight Systems, your Ladyships, the NCLT Mumbai had clearly held, your Ladyships, there would be 3 particular paragraphs from which we could infer the objective of Section 10A as held by NCLT Mumbai. Your leaderships, it has been stated in the case under the heading analysis and findings of NCLT that ordinarily a party to the litigation is entitled to seek amendments of its pleadings in order to correct mistakes or to bring clarity of facts and figures or to add or omit certain facts or circumstances. However, the question that this adjudicating authority needs to consider in the present matter is whether FCs are attempting to correct any error or omission or bringing new facts or revised cause of action. Your leadership by the present IA, the attempt of FCs is to shift the date of default from 5/9/20 to 1/4/2021 to escape that intended legislative bar of Section 10A by stating that Housing Society was informed in September 2020. Your leadership, this particular amendment of dates, if this was allowed to be made, it would certainly make the main application prima facie maintainable, as it would allow the FCs to get away from the full legal bar. Your leaderships, then the NCLT categorically held, if we allow this IA, it would have the effect of negating the legislative bar filing applications for initiation of CIR during the COVID-19 pandemic era. Further, we are conscious of the settled proposition of law that an amendment of pleading cannot be allowed, which takes away the valuable defense available to the opposite side. Your leaderships, therefore, the NCLT Mumbai held, we are of the considered opinion that it shall not be right in law for an applicant under Section 7 of the IBC to change the date of default.
But what about continuing default here? This was again a question I had posed to the appellants. I'm posing it to the respondents as well. With
Indeed,
respect to each OTS that has been proposed and not adhered to, does it not become a continuing cause of action?
Indeed, your leaderships are correct with their reasoning. However, your leaderships, it is pertinent to note that the date of default that was brought before the NCLT in the first matter was brought through by the appellants itself, your leaderships. Your leaderships, the respondent did not have a say in the cause in the date of default that the appellants were setting, your leaderships. Your leaderships, therefore, the reasoning that they had given, your leaderships, we agree with that. Your leaderships, the reasoning in which they had agreed that the first date of default, uh, that is the date which is barred by the Section 10A application, your leaderships, is applicable. If your leaderships are satisfied with my answer.
You can go ahead with the next.
Much obliged, your leaderships. Your leaderships, therefore, the appellant cannot escape the statutory bar by retroactively claiming a different default date, as this would nullify the protection Parliament intended to give to corporate debtors during the pandemic. Therefore, if your leaderships are satisfied with my submission under issue 1, the council would like to proceed with their submissions in issue 2.
Sure.
Much obliged, your leadership. Your leaderships, it is humbly submitted before the honorable court under issue 2 that mentioning of date of default is indeed mandatory in applications under IBC. Your leadership, again, the argument set forth by the respondent in the instant issue is twofold. Number one, that mentioning the date of default date is a strict mandatory requirement. And second, that mentioning the date of default is a conscious admission and not a correctable error. Your leaderships, it is humbly submitted under
Do you have
submission 1.
any precedents on this? Sorry.
Indeed,
Sorry.
indeed,
Go
your
ahead.
leaderships. Indeed. Your leaderships, the argument is also twofold. Your leaderships, number one, that mentioning the date of default is a strict mandatory requirement because your leadership under part 5 of form 1, the date of default is a mandatory statutory requirement under the IBC and not a directory provision as argued by the appeals. That can be changed that way. Your leadership's talking about the precedent. The Honorable Supreme Court in Macquarie Bank Limited versus Shilpi Cable Technologies Limited distinguished between mandatory requirements and directory requirements. Your leadership, the court held that requirements that trigger the code and go to the root of the application are mandatory. Your leadership's applying this particular test, the date of default is mandatory because number one, it triggers statutory consequences. That is to say, without a specific default date, the NCLT cannot determine limitations under Section 238 of the IBC, which
Will you be
allows
able
for
to distinguish
limitations.
the case that was cited by the appellants?
Sorry, your leaderships.
There was
If
a
I
case
may,
cited by the appellants which specifically said that if the date of default can be determined by the documents on record, it's not necessary to put it in the form. Is there any possibility of distinguishing that case?
your leaderships, as far as the respondents have gone through the memorial of the appellants, we were unable to find any case that had been cited by the side appellants.
Okay.
However, your leaderships applying this test of Shilpi Cable Technologies case in our matter, your leaderships, it is pertinent to note that without the date of default, the NCLT will be unable to determine limitations under section 238 of the IBC, and it cannot compute limitation under Article 137 of the Limitation Act. And your leadership, secondly, it goes to the root of maintainability. That is to say, in essence, determine the existence of default under section 7, clause 5, your leadership. Your leadership, it is humbly submitted under sub-issue 2 that mentioning the date of default is a conscious admission and not a correctable error. Your leaderships in Ramesh Kamel case, the Supreme Court held that attempting to change the date is plainly untenable, as it is contrary to the discourse made by the appellant, and because the demand notice triggers further actions in the insolvency process. Your leaderships, if the honorable bench is kind enough to grant me 30 seconds of extension, I'll be done with my submissions. Much obliged, your leaderships. Your leadership, the Honorable Supreme Court held that attempting to change the date is plainly untenable and is contrary to the disclosure made by the appellant, and because the demand notice triggers further actions in the insolvency process. Therefore, your leaderships, the only reason for now claiming 1 April 2014 as the date of default is to escape the statutory bar of Section 10, which is, pardon my language, your leaderships, a strategic manipulation and not a mere error. Your leaderships, this is the extent of my arguments. If the honorable bench has no further questions in relation to issue 1 and 2, I would like to pass on the dice to my co-counsel.
You may proceed.
Much obliged, your leaderships. It was an honor to argue before the honorable bench.
Now I request the speaker 2 of the respondent side to proceed.
Is the council audible and visible to the ladyship?
Yes, you are.
Much obliged. Respected ladyship, the council recognizes the gracious presence of its honorable bench. With your permission, the council would like to proceed with the issues.
Sure.
Much obliged, your ladyship. Your ladyship, I am speaker 2 and I will be addressing the issue 3 and 4 of the current matter in 13 minutes. The first one is whether or not the date of default changes based on facts and circumstances, or is it to be taken as a date of NPA in all bank matters? The second issue is whether or not a case can be admitted if the default has occurred and the application is within the limitation despite an error in the date of default. Your ladyship, in the third issue, the council contends that the date of default cannot be changed based on facts and circumstances, and it is not to be taken as a date of NPA in all bank matters. It is humbly submitted before this honorable court that an application filed under Section 7 of Insolvency and Bankruptcy Code, the date of default cannot be altered by the financial creditors on the basis of convenience or subsequent circumstances. Furthermore, it is not mandatory in every case that the date of NPA on which an account is classified be treated as a date of default. Your ladyship, in the first application filed by the appellants, the date of default was stated to be 1 May 2020. This application was dismissed as it was hit by Section 10A of the IBC. The subsequent appeal was also dismissed by NCLAT on merits. The appellants have now approached this honorable court after their second application was rejected, where they have merely substituted a new date of default to overcome the statutory bar. This conduct clearly reflects a pattern of misuse of judicial process, your ladyship. If such practice is permitted, any litigant whose application is dismissed can simply modify the date of default and refile the proceedings, thereby repeatedly invoking the jurisdiction of adjudicating authorities. This not only undermines the finality of judicial decisions, but also imposes an unnecessary burden on the court. Your ladyship, the date of NPA shall not be taken as date of default in all bank matters, as each case differs via facts and circumstances in each bank matter. Although it is mandatory that there shall be a date of default mentioned in the suit, making the NPA the standard date compulsory for all bank matters would mean that we are taking the right of financial creditors to choose the date of default as per their terms, and it also takes away the right of corporate debtor to restructure the debt default as per their terms. Your ladyship, there are several matters wherein the adjudicating authority, even when the debt was established, has rejected the application only on the pretext that the date of default is not mentioned. Your Ladyship, if you allow, I would like to present my compendium to show the case.
Please.
Much obliged, Ladyship. Your Ladyship, is the compendium visible?
Yeah.
Your Ladyship, I would like to draw your attention to the case LBF Publication Private Limited versus ANA Business Consulting Private Limited.
Which court, which year?
Your Ladyship, I would like a moment of indulgence. Thank you, Your Ladyship. Your Ladyship, the case is of NCLT Delhi. In this case is of Section 10A of IBC, and this was placed after year 2021.
Okay.
The facts of this case goes as the appellants, they did not mention the date of default in their suit proceedings.
Can you show me the relevant paragraph from the case?
Yes, Your Ladyship. The highlighted paragraph is this. Though there exists debt in the absence of due date, the date of default could not be ascertained. Hence, this petition does not satisfy the condition under Section 8 of the Code. The example, the occurrence of default. In the view of the above, we find the present case fit for dismissal. In this case, Your Ladyship, the court held that due to the unmentioning of the date of default in their suit, the court is unable to identify the limitation, and also it does not satisfy the conditions under Section 8 of the Code. Thereby, the respondent contends that the mentioning of the date of default is compulsory and mandatory, as also said by the speaker 1 of the respondents. Your Ladyship, the same has been held by the Honorable Enclave in the case of Ramdas Datta versus IDBI Bank Limited, where it was observed that the date of non-performing asset cannot be taken as a date of default for limitation. Because Your Ladyship, contended by the respondents, there can be many date of default, but there's only one date of NPA. And it is a right of the financial creditors to choose their date of NPA, which was exercised by the financial creditors in the first application. As mentioned,
So as per you, what should be the date of default in the present facts?
Your Ladyship, thank you for the question. In the present matter, the date has already been chosen, which was date 1 May 2020 in their first application. As contended by the side appellant, they have contended that in the first application, the date of default, it was not wrong. It was not technically wrong, which is what we are contending, Your Ladyship. If the date of default was not technically wrong, then there is no point of placing another suit for the same facts and circumstances, and the respondents see no reason as to why this case would not be coming under res judicata. Your Ladyship.
So I'm posing a different question. I said in these
Yes,
facts and circumstances and without prejudice to your rights, as per you, what is the correct date of default? Is it not when the asset was declared as non-performing? Or
yes, Your Ladyship.
Or was it the one-time settlement that did not go through? As per you, which is the date of default?
Your Ladyship, the appellant side could have chosen the date of the NPA as their date of default if they had exercised their right in the first place in the first application, but they chose their date to be 1st May 2020.
But isn't that contrary to what
according
you
to the
exactly said,
respondent,
that NPA date should not be the date of default?
I apologize, Your Ladyship. The internet connection was cut off. Could you again repeat the question?
I'm saying, is it not contrary to the statement that you just made that the date of NPA should not be considered as date of default?
Your Ladyship, I would like to draw your attention to the issue 3, which asks the question, should the date of NPA be considered the date of default in all bank matters? And we are contending that it should not be considered as date of default in all bank matters. It is not compulsory to put date of NPA as the date of default in all bank matters, Your Ladyship. That is the contention we are putting forth.
Which is correct. So
Yes,
then what becomes the date of default?
The date of default could have chosen by the appellant any date which could be the NPA, which could be the date of default that they did choose, which was May 1, 2020, which we are contending, which was correct. May 1, 2020 date of default was correct, Your Ladyship.
So as per you, May 1, 2020 was the correct date of default?
Yes, Your Ladyship. I apologize.
What is the reason for that being the correct date of default?
Because leadership, if I reiterate the facts, there was an one-time settlement done between the both parties. There was an agreement, there was a meeting of mind between both parties, which led to the one-time settlement, which the corporate debtor was unable to pay later. It was the time of the COVID, but even after that, we put other proposer of OTS in good faith to repay our debt to the appellants. Your ladyship, because there was a new agreement in the year 2020, it again resets the timeline. And because there was a new agreement in the year 2020, the date of default being 1 May 2020 is correct.
Okay. You can proceed with the next issue.
Thank you for the question, Your Ladyship. If the Ladyship is satisfied with the Council submission of issue 3, may the Council move on with the fourth issue, Your Ladyship?
Please proceed.
Much obliged. Your Ladyship, the Council contends that a case cannot be admitted if the default has occurred and the application is within limitation, despite an error in the date of default. Your Ladyship, it is humbly submitted before the Honorable Court that present application, despite being within the period of limitation, is barred from admission as the date of default is not technically wrong. And any amendment to the date of default would give rise to a new cause of action with the similar facts and circumstances. In the case of Inakshi Sopti and others versus Starlight System Private Limited, the Honorable NCLT Bombay Mumbai bench held that it may not be appropriate to allow the IA for amendment of the date of default without any valid justification, Your Lordship, especially when the amendments give rise to a fresh cause of action. It is also observed that we are of considered opinion that it shall not be a right in law for application under Section 7 of IBC to change the date of default. We need to be cautious if the change of default cuts the very root of maintainability in the main application. Your Lordship, this statement by the NCL
I think there's an internet issue, no?
Your Ladyship, if you would be considered enough
That's
to
okay,
grant
that's
us just
okay.
1 minute.
That's okay. That's okay.
Much obliged, Your Ladyship.
Your Ladyship, I apologize for the net connection.
No problem. No problem. Go ahead.
May I continue?
Yeah, sure.
Much obliged, Ladyship.
But Master, can you just give them the extra 1 minute since there was an internet issue?
Yes, yes,
Sure.
sure.
Thank you, Your Ladyship. Your Ladyship, it is humbly submitted before the Honorable Court that the present application is barred from admission as the date of default is not technically wrong. I had submitted the case in Inakshi Sopti and others versus Starlight System and Private Limited, in which the Mumbai bench reiterated our point as to how the amendment of the date of default may give rise to a fresh cause of action in the application, and which will come under res judicata, your lordship, which I will prove with my points. The reason why I think the respondent side think that it will cause res judicata is because even if the appellant side do change the date of default, the facts and circumstances will be the same, your lordship. It will cause res judicata. Date of default, changing the date of default will be a sign of bad faith from the side of appellant, your ladyship. There will be prejudice to our side, and there is simply no defect and already in the date of default that was chosen previously in the first application. Going back to the bad faith part, your ladyship, the respondent side contends that the respondent side had all intention to repay their debt, which is proven by the subsequent Otis proposal, which was sent to the appellant side from year 2014 till 2020. And even after it was considered default at 1 May 2020, we again sent 2 more Otis proposal to the appellant side, your ladyship. Your ladyship, it is also to be noted that the appellant side did not revert back to any of our Otis proposals until the year 2020. The appellant side contended that there has been a chain of correspondence between the parties, which the respondent side would like to push the facts upon, that there has been no chain of correspondence, as there has only been one-sided communication from the side of respondent, as we have sent Otis proposal back uh, 5 to 6 times to the side appellants, of which we did not receive any sort of communication back. So it proves the fact that we had always been in good faith, and we always had an intention to repay the debt that we had taken from the financial creditors. Your ladyship, the next point is that simply by changing the date of default from May 2020 to their original date of NPA, it will be prejudice to our side. As your ladyship, the first application has already been struck down by section 10A. It has already been decided. Now, changing the date of default at their convenience will change the course of the proceedings, which has already been decided, your ladyship, while the facts and circumstances being the exact same, your ladyship. Your ladyship, it also changes. It also takes the right of the corporate debtor to restructure their debt, your ladyship. There has already been the meeting of minds in year 2020 when the Otis proposal was accepted by the financial creditor, and so there was a new agreement. Now, your ladyship, if we give the right of changing the deed of default to financial creditors, there will be no right or no space for the corporate debtor to restructure their debt, your ladyship. Your ladyship, if if the ladyship is satisfied with the arguments of issue 4, I would like to proceed with the prayer.
Please proceed with the prayer.
Much obliged, your ladyship. Wherefore it is prayed, in light of the issues raised, arguments advanced, and authorities cited, that this Honorable Supreme Court may be pleased to urge and declare that the second application under Section 7 of IBC 2016 is not maintainable in the present case and barred by law. That mentioning the date of default is mandatory, that the date of default does not change on facts and circumstances, and it is not to be taken as the date of NPA in all bank matters. That the case cannot be admitted even if the default has occurred and the application is within limitation despite an error in the date of default, and or pass any other judgment, direction, or relief that it may deem fit in the best interest of justice, fairness, equity, and good conscience. For this act of kindness, the respondent shall duty bound forever pray. Your ladyship, it was an honor presenting this case in front of you.
Thank you, guys.
Thank you.
There's rebuttal, right? Or it's not 2 minutes of rebuttal?
Yes. The council would like to raise 3 to 4 rebuttals as opposed to the respondents' arguments. Firstly, with utmost due respect, the respondents have also presented a distorted version of facts on their side and engaged in a whataboutery, as nowhere in the facts of the case was it mentioned that what were the merits of the case on which it was dismissed. Clearly, the NCLT clearly said that the dismissal was on the 10A bar and the NCLAT dismissed it on the merits. So nowhere but it could be construed that the merits taken up in the case could be well within what the NCLT has upheld. That is, it is a bar on the 10A, it's a 10A section as well, and it can be it could be the on those grounds. Further, the 2020 date, which was taken by the appellants, was mentioned and taken as a date of default because it was one of the tranches of the OTS process, and there was no malified intention because it is very evident from the facts of the case that the default has occurred and the acknowledgement has been given by the respondents at multiple occasions. Further, the NPA date was not taken as per a convenience in the present matter. The clarification form states that the date of default can be construed as the date of NPA, and it has been upheld in the case of Babulal Gurzar that the apex court can take the NPA, can be ordinarily taken the date of default as the NPA. Further, if the respondents would have been careful enough to hear the submissions of the appellants, the appellants have submitted that in the Geo Infra Private Limited case, the date of default was clearly mentioned. The date of default was clearly not mentioned, and that is why the case was given. The memo submissions was not the only thing which we were basing our contentions upon. Further, Section 7 the council seeks extension of 15 seconds.
Sure.
Further, the respondents stated that under Section 7 of Part 5, in the Part 5 it's mentioned, but the council would like to correct the respondents about it. In the Part 4, the application under Section 7 is mentioned. Although it is a mandatory to mention the date of default, in many instances and cases, NCLT and NCLAT have admitted the applications even without the date of default, as it is a procedural requirement which can be established by evidence. Further, one of the cases presented by the respondents talked about, which is the LBF publication, talked about the operational creditors in the center of the argument. Hence, the same case is not applicable in the present matter. Thank you.
Courtmaster, I think we're good to
May,
go. Sorry.
uh,
The rebuttals?
may
Are there
it please the
rebuttals?
Honorable Court, the
Sorry.
side respondents would like to, just in a minute, provide some sir rebuttals to the arguments made by the appellants.
We'll give you 30 seconds for it.
Much obliged, your leadership. Your leadership's the sir rebuttals by the side respondents are threefold. Your leadership said like to present the compendium, and your leaderships correct the appellants that it is indeed part 5 of the rules and not part 4. Is the screen visible to the honorable bench?
Yeah.
Your leaderships, this is the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. Your leaderships, under Part 4, indeed particulars of a financial debt is mentioned. However, in Part 5 of the particular rule, your leaderships, particulars of security held, if any, the date of its creation, its estimated value, as per the creditor, is a mandatory bar, your leaderships. Your leaderships, just 15 seconds more. Your leaderships in the moot proposition, much obliged, your leaderships. Your leadership in the moot proposition that had been provided, your leadership in paragraph 9, the meaning of the paragraph is very clear, is crystal clear. Your leaderships, it is stated that NCLT and the NCLAT dismiss the particular petition on merits. Your leaderships, it has been mentioned that NCLAT also dismissed the application on merits. Your leaderships, the final rebuttal by the side respondents is answering the calculation of limitation period. That was the question posed by the honorable bench to the side appellants. Your leadership, the limitation period is calculated through Article 137 of the Limitation Act. Your leaderships also under Section 18 of the Limitation Act, the current petition is though within limitation. However, they cannot change the date of default, your leaderships. Your leadership, that is the extent of our cell. Much obliged, your leaderships.
Thank you, Your Honor, for being here with us. I thank both the Council 1 and Council 2 for being a part of this moot court competition. We sincerely appreciate your time and guidance, ma'am, and your presence added a great value to this round, and we are really grateful for your support and insights. Now I will just stop